Attorney General Dr. Dominic Ayine has indicated that the delay in extraditing former Chief Executive Officer of Microfinance and Loans Center, Maslog, Ferdinand Tamaklo Ationu, is dragging due to U.S. authorities' delay in triggering the process. Ferdinand Tamaklo was convicted in April 2024 and sentenced to 10 years imprisonment on 78 counts, including causing financial loss, theft, money laundering, and violation of public procurement laws, but attempts to get her to Ghana to serve her jail term. The Attorney General, Dr. Ayine, was summoned to Parliament on Tuesday to provide answers for the extradition process, and this was his response.
The request for the extradition of Sedina Christine Tamaklo Atienu was dispatched on 19 July 2024 through the Ministry of Foreign Affairs to the Department of Justice of the United States of America for execution. Our office, that is the Office of the Attorney General, is awaiting the execution of our request to have her extradited to serve her prison sentence in Ghana. The International Cooperation Unit of the Attorney General's Department followed up on our request from the Department of Justice, the United States of the United States of America in September 2025. So if there is any impression being created that I am not taking any steps, this is the evidence that in September, that is just a month ago, I took the step of inquiring from the United States Justice Department the steps that they were taking in respect of the extradition. And they indicated that they are following their extradition procedures in executing the request, and that the fugitive will be extradited as soon as they have satisfied all the procedures.
Dr. Ayine has also been defending the hefty bail conditions investigative bodies impose on persons picked up for investigation on corruption and corruption-related acts, which has attracted criticisms, especially in the Wuntumi, Giftiowari, Osesibe, Entry, Edubahin cases, among others. In the case of the former boss CEO, Edwin Provencal, he had to get the Human Rights Court to beat down his bail condition from 60 to 30 million cedis on Tuesday. The Attorney General, Dr. Dominic Ayine, however, believes these bail conditions are necessary.
Speaker, I have already made it abundantly clear that the Economic and Organized Crime Office and other law enforcement agencies under my ministry are not acting arbitrarily. Bail depends on the crime, the gravity of the crime. And so what we are seeing now is that the sums involved in the criminal investigations are very huge. And because they are very huge, if you set very low bail conditions in terms of the sums, the likelihood is that when the person, the suspect, escapes or is unavailable to stand trial, whatever you are able to extort in justification will not be able to offset the sum that is involved, the criminal liability that is involved. So, for instance, if you have a situation where the suspect is accused of, let's say, causing financial loss to the state in the sum of 1 billion Ghana cedis, or stealing in the sum of 31.1 million Ghana cedis, you cannot set bail terms that are, unjustifiably low. So it is the magnitude of the offenses we are dealing with that dictates that we set bail sums that reasonably justify the crimes that have been committed or alleged to have been committed.
Now let's learn a few things this afternoon. We've got Professor Kwejo Appiagyei. He is a law lecturer at the University of Ghana. Prof, thank you so much for joining us this afternoon. You certainly have heard what the Attorney General has been saying on bail conditions, but the conversation about abuse of rights of suspects has been arising occasionally. What's your position on what he says, just opposing it on the media conversations?
Yeah, the issue raises the question of the relationship between human rights and criminal law. The relationship can be cordial and at the same time can be confrontational at a certain point in time. Here we are talking about the fact that sometimes criminal law can be harsh in its application. And when it so happens, human rights law will have to be applied to mitigate the harshness of the application of criminal sanctions or any aspect of criminal law. And here we see a situation where the Human Rights Court has come in to say that the bail condition is being too harsh. Bail should be used to punish a suspect or an accused person. Bail is to be applied to ensure that the person who is applying for the bail will not interfere with the investigations or be a flight risk, that is to run away from criminal justice, and among a few other situations. So in this context, the court coming to that conclusion indicates that bail is being used as a means to punish the accused person in this matter. And so if that's the court would then have to come in to make sure that the rights of the accused person in this case is protected, while at the same time ensuring that criminal justice will be served. And so I think that's the basis for the court coming to that conclusion. So
Prof,
on the
again,
part of the Attorney General,
right. Please proceed.
I think he's also, sorry, you can go ahead.
Please proceed, Prof.
Okay, so on the part of the Attorney General, he is also trying to justify it on the grounds that is as a result of the gravity of the offense, which is also a good argument to make. And I believe the court may have taken that into account as well, because if the money given, the surety and the bail conditions are such that it is loose, in case the accused person runs away, then it will be a difficult situation for the state to be able to offset the amount of money that the accused person is supposed to pay back to the state in case he loses the matter. Yeah, so there has to be a fine balancing act, which I think the court, based on the evidence before it, came to the conclusion that in this situation it was too harsh.
Prof, help me here. So is there any part of the bail bond that is quite discretionary to the person who is imposing it on the accused person, so much that we can say that it can be used as a punishment at all? Is it not just what the law says, or there's some bit of discretionary in any of it?
There is some discretion in the application of the bail conditions. And so that is why we also have to refer to application of discretion by a state authority, that it should not be arbitrary and it should not be frivolous and so on. So those standards in the application of discretion should also apply. Okay. And I think that it's a point that the court will weigh in coming to the conclusion whether the bail condition is too harsh or not. Right. If that application is not, that test is not done, then it could lead to a situation where the accused person will have his rights violated. So the fact that the accused has committed an offense does not negate or delete the rights that he is entitled to enjoy as a human being. And in fact, as an accused person, new rights would accrue to him to ensure that at the end of the day, justice is served in his case or her case.
Prof, thank you so much. That's some legal education this afternoon. Thank you for joining us.
Pleasure.